Business owners love to copy and paste these little no bad reviews or social media blasting aloud clauses into their contracts. But they're not only legally unenforceable in most cases, they can backfire badly. That's because you can't contract away free speech, which means that clause in your contract banning bad reviews is not only not valid, it could get you sued for a consumer protection claim. Let me explain. Hi there. If you're new to my YouTube channel, my name is Paige Griffith, and I'm the CEO and lead attorney behind The Legal Page, which is an online legal education platform and contract shop for small businesses. We help you get legally legit in no time without all the overwhelm. So you've put your heart, your time, your energy into starting a business, and now you're getting great reviews and you're hitting your stride. But then for whatever reason, you have an angry client. Maybe there was a scheduling conflict, a communication breakdown, or things really didn't turn out how they were supposed to. Now they're threatening to leave a bad review on Facebook or Google or Yelp. So, can your client contract protect you from a bad review? Maybe you've heard of a non-disparagement clause. That's a part of a contract that says someone can't talk badly about your business. Is that the answer? As an attorney and contract creator for small business owners, I hear this question often. And I help photographers, wedding planners, and many other business owners who value client reviews. So let's talk about what you can do and what you can't do legally in your client contracts. First, let's discuss what is a non-disparagement clause. Disparage means to talk negatively about someone or something. This can hurt a person or a business's reputation. And a non-disparagement clause is a part of a contract that stops someone from bad-mouthing a person, a company, a product, or a service. A non-disparagement clause is useful for employers and business-to-business relationships, so B2B relationships. For example, we include non-disparagement clauses in our employment contract template and our independent contractor agreement. And this would be to prevent any disgruntled workers from talking badly about your business. We've also written out a non-disparagement clause template that you can add into your contracts. But a non-disparagement clause does not belong in contracts between you and your clients. For example, if you're a wedding photographer, it is not legal to prevent the spouses from posting a review about your wedding gallery. So I'm sure you're thinking here, Paige, why can't I use a non-disparagement clause to prevent a bad review? When you start working with a client, it's important to set clear expectations and protections for both of you in a good service contract. And if you decide to stop working together, it is essential to protect you and your business with a cancellation contract. But remember, you cannot use either of these contracts to silence a client from writing a truthful review, good or bad. And that's because consumer reviews are protected by the Consumer Review Fairness Act, or CRFA. The federal government established the CRFA in 2016. This law makes it so that a contract provision is automatically void if it tries to stop an individual from sharing a review about goods, services, or the conduct of someone who is a part of the contract, charge a fee or penalty for providing a review, or transfer ownership of an individual's review with some exceptions. The CRFA stops businesses from using gag clauses or contract clauses that prevents customers or clients from leaving honest reviews. When customers can share that kind of feedback, good or bad, without fear of punishment, this helps other customers make more informed decisions. So based on this law, a court cannot enforce a clause in your contract that limits clients from leaving an honest review, even if it's negative. If a business violates this act, the FTC and state attorneys could legally sue you. So what are the kinds of reviews that you can restrict? Keep in mind here that the CRFA applies to consumer reviews only. You can use a non-disparagement clause in an employment contract or an independent contractor agreement, or really any other B2B contracts. But even your clients don't have unlimited freedom to post whatever they want about your business in review format or in social media blasting format. There are some limitations as to what types of reviews the CRFA protects. For example, the CRFA Act doesn't stop you from restricting reviews that contain defamatory content, and that's factually false statements that can cause real harm. Anything that reveals confidential information is harassing, abusive, obscene, or discriminatory. Anything that's unrelated to your business's goods or services, or are clearly false or misleading, or unlawful for other reasons. So while clients can share honest opinions in reviews, anything that falls into these unlawful categories is not protected. So here is my legal take on how to deal with bad reviews. Negative reviews are honestly just a reality with consumer protection laws. Still, it's really no fun when a client relationship goes sour. No one wants to see or look at a bad review pop up on their business's page. And sometimes client reviews can feel really unfair, upsetting, or pretty exaggerated, right? If you respond to a review online, I want you then to do it in a calm, professional, and collected way. For example, here's how a wedding photographer could respond to a bad review related to photo edits. I am sorry to hear that you weren't happy with the editing of your photos. I know that these photos are really important to you, but my editing was consistent with the style that I've posted on my website and galleries and social media. I'm happy to adjust the editing on the top 10 photos complimentary for you, and I hope this will help. So if you do end up with a negative review, try to keep it in perspective. After working with many creatives and service providers, I can tell you that negative reviews are not usually as big of a deal as we think. People are used to seeing a few negative reviews, even for the best companies. In fact, I've learned that having less than 5 stars can actually make a business seem more real and legitimate. A business with only 5 stars can seem pretty fake, right? So think of consumer reviews as an opportunity to address concerns and improve your business. Focus on seeking out customer feedback and asking happy clients to leave you reviews. But what do you do if a review is 100% false and not true? For the most part, as long as a review is truthful and based on the consumer's honest experience, it is protected. Statements of opinion, for example, I didn't like their service, are generally protected. But false statements about facts, so they lied about their product, could be a basis for defamation. However, there are some steps that I recommend you take before taking any legal action. If someone leaves you a review that is completely far-fetched and untrue, here are the steps that I would suggest that you take to resolve it. Number 1, reach out privately to the reviewer. Contact them calmly and ask the client about the review. Politely just say, okay, could you clarify this or remove the false statement? Oftentimes with some positive communication, you may be able to resolve the issue directly with that client. The second thing is to try and get it taken down through the platform. Most review platforms like Google, Meta, Yelp, Amazon, they have policies against fake or misleading reviews. So you can go report a review to the platform and ask them to remove it. You may need to provide some evidence that the information was false, so just remember that you may need to document some things and submit it with your claim. And the third thing is just respond professionally. Don't forget to respond. If you can't get a review taken down, you can and should respond to it politely. Respond with your truth to help others who are looking at this review and potential clients down the line understand the inaccuracies. But always try to avoid any back and forth arguments. You want to show that you were willing to do or go above and beyond for the client. This way, others reading your response will see you as a true professional who responded in a professional way. And usually, potential clients and customers can read through the lines there. And the fourth thing you could do is possibly take legal action. If the situation is serious and you followed all of these previous steps that I just told you, you might consider suing for defamation. But remember, to prove defamation, you would need to show that someone made a false statement about you that they claim to be factual and was indeed truly false, that they caused harm or injury or loss to you. So you actually have to prove damages and loss to your business. And unlike disparagement, defamation goes beyond a client describing a negative firsthand experience. For example, if a client claims that you failed to show up for you to perform your services when you clearly did, or that you stole or damaged property, which you would probably never do. So there are several legal requirements to prove defamation. It is always a good idea if you go down this route to talk to an attorney about this issue, because defamation is just oftentimes very difficult to prove. It is not impossible, but you need to make sure that you have all of your legal ducks in a row and documentation to be able to submit a defamation claim. Now I want to talk briefly about the benefit of a confidentiality clause in your cancellation contract. So what if you're ending a relationship with a client and they're threatening a bad review? In these situations, I recommend a cancellation agreement. So agreement, contract, used interchangeably. A cancellation contract gives you options like keeping fees paid, partially refunding, or refunding all of your fees. Our cancellation contract here at the legal page, this template has all three options written out for you depending on the situation that you are undergoing. Although you can't include a non-disparagement clause in your cancellation contract, you can have a confidentiality clause, and you should have one. And no, a confidentiality clause doesn't stop your clients from writing reviews. However, it does prevent them from sharing about the details of how you ended the client relationship. This means they cannot tell others how much you refunded them, the fees you kept, what other services you did or did not deliver before the termination, how the settlement was wound up, etc. This is really helpful to you as a business owner because it keeps others from knowing too much about the behind the scenes of your business when you're dealing with kind of client debacles like this. And here's my final thought. Legally speaking, you cannot use a non-disparagement clause in a client contract to stop a bad client review. However, you can use a cancellation contract with a confidentiality clause. That won't stop a client from leaving a review, but it certainly will prevent them from sharing details about your cancellation agreement and how you guys settled everything. Unfortunately, bad reviews are just sometimes a sticky part of running a business. We've all had them, but don't get too hung up on a bad review. As you continue to deliver great services, you will get through it. You've got other great client reviews. You've got this. And if you want an easy-to-use, customizable cancellation contract with a solid confidentiality clause to protect your business, just click the link below this video in the description and I'll get it over to you. Thanks so much for watching, and I'll see you in the next video.